So we are going to now start our discussion, and we will start by exploring a crucial question. So we would like the speakers to share their ideas on how do you see the colonial legacy and power dynamics reflected in the international child rights framework, and particularly in the conventions like the Convention of the Rights of the Child and the International Convention of Civil and Political Rights and Economical, Social and cultural rights. So this is our first umbrella question. Each of you will have about 3 minutes to share their perspective, and maybe Hazel, we can start with you.
Yes, thank you, Paola. So let me say that this question is one of the very interesting and not easy to answer, I think, because colonial legacy and power dynamics are deeply embedded in the international child rights framework. When these conventions were drafted, they largely reflected the perspectives and interests of Western powers that had shaped global legal systems throughout centuries of colonialism. This is evident in the way that certain rights, particularly civil and political rights, are prioritized over others such as collective cultural right and socio-economic justice, which are more relevant to formerly colonized states. The CRC, for example, presents a universalized conception of childhood rooted in Western ideals of dependency and innocence, which may not align with the lived realities of children in the global South. In many of these societies, children contribute significantly to family, community life, yet this agency is often overlooked. And the power imbalance between, the power balance persists through international bodies dominated by wealthy nations, dictating the standards for compliance and funding prioritized, marginalizing local voices and indigenous understanding of child well-being. Colonial legacy becomes evident in historical debates regarding provisions in these conventions, particularly around sensitive issues like marriage age. When I was studying the process of adopting the text of CRC, there was very interesting discussion about not CRC, sorry, International Covenant on Human Rights. There was a very interesting discussion about marriage age. So, for instance, Western countries emphasize the need for clear, universal legal standards, proposing the use of both legal majority and the age of consent to ensure that physical and psychological maturity were considered. Their focus was on formalizing protections through detailed legal definitions aligned with national legislation, while post-colonial countries emphasized the diverse social and cultural realities of their regions. They questioned the relevance of imposing rigid legal standards, arguing that maturity and readiness for marriage were complex and context dependent. During the discussions of the International Covenant on Human Rights draft, the representative of Chile, for example, stressed that focusing solely on physical maturity risked promoting early marriages without considering psychological and social development. Or India's representative pointed out that terms like full age were unclear and didn't align with their cultural understanding of maturity, skepticism about universal legal definitions imposed by global frameworks. These debates, this is just one example, but these debates illustrate the tension between global legal norms and local customs. While these documents sought to universalize child protection standards, they often reflect Western legal priorities and development models. By centering Western definitions of maturity and family, the framework failed to fully integrate diverse cultural perspectives, particularly from post-colonial societies. These ongoing power dynamics highlight the unequal influence the former colonial powers have had over the development of international legal standards. Such frameworks need to better account for the varied cultural, social, economic realities that shape children's lives in different regions. I think for now that's it for this question.
Yeah, thank you very much. That was very insightful. Mark, what do you think? You muted.
Thank you. Sorry about that. Well, first of all, before I sort of dig into the points of the sort of provenance of international children's rights, I want to say thanks. Thanks for the invitation to participate. I think it's an important discussion, and the voices that are constellated here, I think, have a great verve to them and a vibrance and ought to be heard. So I agree completely with the point that are international children's rights really international? And I'm somewhat skeptical about that as well. And this is a problem that's not only in the children's rights field, but it's embedded within the entire structure of the creation and formulation of international law across the board. I'm recently doing a reasonable amount of work on Judge Paul, the Indian judge on the Tokyo Tribunal, and his scholarly writings beyond his dissent at Tokyo. And this was one of his major concerns. So this is a concern that's been going on for a very, very long time. This mythologizing of the universal when it really masks, in certain ways, a profound, partial internationalism as opposed to a complete, integrated, synergistic internationalism. So this is one critique in which I heartily concur. And I do believe it is a legacy of the fact that the architecture of international law, is certainly the foundation thereof, is decidedly not universal. But I would add that there's two other, I think, offshoots of this partial history of international children's rights law. And whether these can be related to a colonial experience or a racist legacy or, embedded misogyny, I don't know. I don't know also whether it matters to affect that connection, because the second main problem that I see that hampers the effectiveness of children's rights is the phenomenon of gerontocracy. In other words, the phenomenon that societies and the international legal order remain largely driven by adults. They're gerontocratic. They're run by adults in adult ways, in which adult thinking of what children ought to be doing dominates the entire scene. A lot of children's rights, I think, are hampered by the fact that many adults who see themselves as activist lawmakers, I'm not so certain are actually comfortable really listening to what young people have to say. I'm not so certain that a lot of adults making and enforcing international children's rights law are really interested in a very full empowerment of children's rights. I think certainly in the area in which I work extensively is the child soldier area. There's a perennial problem of just seeing war and political activism and violence as absolutely destructive and hellacious for young people. But the reality is, in a lot of places in the world, young people become involved in violences as methods of political agency, as making the most out of a very bad situation they might face. We see this in the post-conflict with child soldiers, where adults tell young people what the best methods of rehabilitation and reintegration are for them, and often don't listen to what young people think might be in their best interest. So I would say the second major area of concern is gerontocracy. Who is involved in making children's rights? And the point of the matter is, it's generally not children. They are these welfarist beneficiaries, once again, of adult wisdom. And there's something deeply controlling about that. And I say the last point that I'll quickly make, because I think I've gone on for a bit, that I also see as a shortcoming in the general area of children's rights is that we are very focused on core civil and political rights, as was mentioned previously, very elegantly. But we are also focused on certain kinds of violences. For example, I think we spend a lot of attention on children's intersections with armed conflict, terrorism, and war. I don't think we spend a lot of time on intersections between children and forms of violences that might involve criminal violence, that might involve the violences of environmental destruction. And it is here where I think we ought to again be diversifying in an epistemological sense, where we think of what really matters to children. So I would really, in addition to the lack of internationalism, I would chide the plague of gerontocracy. I would encourage adults to be much more brave in listening to what young people say. And then I would also encourage a much broader understanding of what violence is than necessarily just these core civil and political armed conflict contexts. Thank you.
Great, thank you so much. No, absolutely. Shall we maybe hear from Natalia now, if we can? She has been given obviously the same sort of questions, so let's hear from her. Oh no.
Can't you hear, Paula?
No, I can't hear.
Just a minute. Let's try again. I think now should be fine.
That is a big question, especially concerning how historical power dynamics shape international frameworks. Colonial legacy often influenced these frameworks in several ways. First of all, drafts of the International Bill of Human Rights and CRC were finally completed just after the era of decolonization. Young nations often reproduced the legal and organizational templates of the former colonial power. On the other hand, the former metropolitan powers were happy to provide models of legal regulation, including in the field of human rights. Some could not yet bring anything to this era, while others considered their own experience to be universal. Secondly, the tension between universal human rights and cultural diversity is evident. Even basic concepts such as child and childhood are interpreted differently in Europe and in the global South. These conventions are the result and generalization of the experience of the Euro-Atlantic civilization, as well as the concept of international law in general, international law of human rights, and international juvenile law. All of them are a Euro-Atlantic phenomenon. Thirdly, economic and social rights often highlight disparities rooted in colonial histories. Resource allocation remains unequal, impacting children's rights to health, education, and living standards. Well, the question arises, Does this mean the need to abandon international mechanism for protecting children's rights? My answer is no. International law is a Western invention, but this invention is available for all societies to apply. The challenge lies in the different capacities of states to implement child rights provisions effectively. European countries, for example, are generally more prepared than many African nations to enforce the provisions of the CRC and other international treaties.
Right, thank you.
Yeah.
All right. I guess we can delve a bit deeper into basically linked question, which is talking about colonial legacies and talking about conception of childhood and Eurocentric conception of childhood, which leads us a bit to the second question, which is to what extent you think that the narrative of international justice has the savior of innocent victims perpetuate colonial legacy specifically in this field. We know that it's a tendency that we might see across different fields, but how does it play out in the field of children's rights? Hazel, are you happy to go first again?
Yeah, thank you. The narrative of international justice as a savior of innocent victims perpetuates colonial legacies by reinforcing a hierarchy in which the global north seen as a protector of the global south. This narrative echoes colonial justification for intervention, where imperial powers portrayed themselves as civilizers saving the helpless from barbarism. International institutions such as ICC often focus on individual criminal accountability without addressing the structural causes of violence and instability, many of which have roots in colonial exploitation and ongoing economic domination. Children are frequently depicted as passive victims, which disregard their resilience and capacity for agency. This framing also delegitimizes local justice mechanisms and traditional forms of conflict resolution, implying that justice must come from external, superior institutions. As a result, the deeper inequalities driving harm and exploitation remain unaddressed, while international actors continue to exert control over narrative of justice and rights. The narrative of international justice as a savior perpetuates colonial legacies by framing global institutions as external protectors of innocent victims, let's say, in this global south, without addressing the underlying structural cause of harm. Historically, the narrative has reinforced the view that justice, expertise, and solutions must come from the global north. The process of developing juvenile justice standards under CRC, for example, demonstrated the dominance of Western legal models, although from representatives from various countries contributed, from post-colonial states, to the drafting process of CRC. Western countries often set the tone for legal language, such as procedural protections and sentencing limitation, juvenile justice frameworks. This savior mentality ignores the fact that many international crimes have their roots in systematic inequalities, often stemming from colonialism, such as poverty, resource exploitation, and political instability. And if we talk about CRC, for example, The articles which enshrines provisions on juvenile justice are 37 and 40. And during the drafting of these CRC articles, post-colonial states expressed concerns about the imposition of rigid legal norms, advocating for cultural sensitivity in areas like detention, rehabilitation, and procedural guarantees. Rather than empowering local communities and systems to handle child protection and justice, international intervention often dismiss or marginalize indigenous and community-based approaches. This power imbalance continues to reflect the broader colonial legacy in global governance, where countries with greater political and economic influence shape the standards and policy imposed on others. Our common requires shifting the focus from external intervention to empowering local, context-specific justice system that prioritize both structural reform and the voices of affected children and communities. So basically, what I'm trying to say that, again, in this question, we see how global north again has a power when we say about justice, and it goes the view of global north doesn't go alone with the whatever see global south. So I think that my timing is off, so I will stop here. Thank you.
Mark.
Yeah, I mean, I agree with very much of what Isel said and the way that she said it and contextualized it, yet also addressed this phenomenon of saviorism on a universal level, because I do think it is that. Let me give a more specific example from my own work. So about 10 years ago, I published a book called Reimagining Child Soldiers. And the book opens with discussion of what I see as three main images, frames, ways in which children afflicted by violence, child soldiers in particular, are portrayed through the processes of media, law, and politics. The first image is that of the faultless passive victim. Isel mentioned the word passive, and this is the image that is largely given over by transnational human rights activists to child soldiers who are embroiled in conflicts far away from the West, in other parts of the world, and who are hurt by people in other parts of the world, and in turn, these child soldiers also they hurt people. But the entire phenomenon of this violence and the faultless passive victim narrative goes largely at the time to child soldiers in African contexts. Then there's a second closely related category, which presents the child soldier as ultimately desiccated, decimated, dilapidated, destroyed by war. And that image is actually cognate to the first one. But there's a third image, and that is of the violent child, the child soldier, the child criminal, as incorrigible, as filled with the devil, as dangerous, as baleful, as loathsome, as condemnable, as someone who does not deserve our mercy, who is tainted and tinctured by original sin and is largely irredeemable. Now, it's very interesting to me. Transnational human rights activists gravitate to the image of the faultless passive victim to describe child soldiers in places such as Africa, Latin America, Asia, and presenting these young people as victims, stripping them of agency, saying they're all innocents all the time, and basing rehabilitation on those, what I have argued, are problematic assumptions in all cases. Now, what happens when children, persons under the age of 18, join terrorist organizations and fight against Western interests, fight against us, our own security, sitting where we are perhaps sitting now, at least where I'm sitting now? All language of faultless passive victim is out the window, and the entire language is the third image of incorrigible demons. Those young people are given no due process protection, are not seen as innocent, are seen as menacing, are not seen as used by adults, but are seen as actors in their own regard, are expressly stripped of the title or nomenclature of child soldiers, are denationalized. In the UK, there's the Shamima Begum case, for example, where this quote unquote jihadi bride is like the government makes a voracious effort to strip her of citizenship and accord no rights whatsoever. So what I would say to tie those two together is what I see not only as a legacy in this regard, but as a problem is our approach to child soldiers is deeply asymmetrical and it's deeply selfish. It's deeply based on what are the saviors scared of. The saviors are not scared of conflict in Mali and Mauritania and Uganda. The saviors are scared of terrorist attacks back home. And I have written a lot on how if international law is going to claim any level of universality, it better also claim a level of consistency in the images that it projects. And it does not. They're deeply selfish, deeply politicized, deeply motivated by fear. So it's a very incomplete saviorism. The angels of the saviors are only partial. And to close on this, certainly in the areas that I've worked in with violence afflicted children, we see excessive indulgence towards, for example, child soldiers in distant conflicts who are seen as innocent when local communities may not see them that way. They may see them much more complicated fashion, as ISIL has already referenced. Therefore, their rehabilitation programming is ineffective and gerontocracy persists. And then, on the other hand, when it comes to young people who threaten security interests in the West, whether they're foreign national fighters, whether they're terrorists, or even domestic criminals, we're pretty scared of them. We don't see them as faultless, passive, longing for a halcyon, beautiful, idyllic childhood they never had. We're actually quite contemptuous of them. And we also don't tool effective rehabilitation and re-socialization programming for them. So it's like this isn't just a theoretical conversation in academia. These precepts and premises really affect actual operational policies to concretely reintegrate. And maybe later on I can come back to some of my views on what effective reintegration is.
Fantastic. Yes, absolutely. Let's hear now from Natalia, and then we'll get back to you.
I find it difficult to agree with the assessment of international justice as a saviour of innocent victims, including children. International justice is often ineffective at full protection. Children, particularly in armed conflicts and genocides. While it offers some compensation to victims, it rarely prevents harm. For example, in 2012, the International Criminal Court emphasized its role in both retributive and restorative justice. President of the ICC, Sam, in his opening statement, stressed that ICC is about much more than just punishing the perpetrators. The Rome Statute and the ICC bring retributive and restorative justice together with the prevention of future crimes. However, today it mainly focuses on financial compensation through the ICC Victims Fund. And the slogan of restorative justice has disappeared from the website of the ICC. In general, international justice mechanism like the ICC often focuses on prosecuting individual perpetrators rather than addressing the broader structural violence, such as economic exploitation, resource extraction, forced displacement that stems from colonial histories. International frameworks like the CRC should be implemented in ways that empower local actors, state actors, rather than reinforcing dependency on Western institutions and international justice institutions. Additionally, international justice tends to prosecute individuals rather than address deeper systemic issues, like economic exploitation, which stem from colonial histories. The application of justice is also unequal. The ICC, for example, frequently prosecutes figures from the global south while failing to hold Western states accountable for their role in conflicts. The same should be said about great corporations. One of the landmark cases is the following: international rights advocates versus Apple, Microsoft, Dell, and Tesla in 2019. Advocates protected and represented Congolese families that filed a lawsuit against major tech companies, alleging a complicity in child labor through their supply chains in the Democratic Republic of Congo. A lawsuit took place in the USA. The USA Court of Appeals dismissed the case, and great corporations, they weren't accountable for exploitation of child labor. However, it highlighted the global implications of child labor and the need for corporate accountability, reflecting the CRC principles on protecting children from economic exploitation.
Thanks, Isel. Right, yeah, that's a lot of food for thought. Shall we move on, maybe as always, back to what we've been discussing a bit in terms of the construction of children and childhood. And the next question, basically, that we prepared for our speaker is: how do you think, or how do the epistemologies embedded in international child rights and protection frameworks possibly reinforce or disrupt colonial and patriarchal legacies and perspective, or how to think about the relationship? Isel, you're going to go first again.
Yeah. Thank you. So the epistemologies underlying international child rights frameworks often reinforce colonial and patriarchal perspectives by constructing a rigid image of the innocent child in need of protection from the state and international institutions. This view aligns with both colonial paternalism and patriarchal legal structure that perceive children, and by extension women, as inherently vulnerable and dependent. These frameworks assume a linear path of development based on Western life stages, disregarding the diverse roles children occupy in other cultural contexts. For instance, as I said before about contribution that children make in family and communal life, which is more than in Western part of the world, and this often marginalized in global frameworks like the CRC, and moreover, by prioritizing over empowerment, these frameworks risk replicating oppressive dynamics that exclude children's voices from decision-making process, as Mark said before. However, efforts have been made to disrupt these legacies through initiatives that emphasize child-led advocacy and intersectional approaches sensitive to race, gender, and cultural context. The influence of these epistemologies is also evident in how non-Western countries were pressured to accept certain articles of the CRC while leaving out provisions crucial to their cultural and religious traditions. For example, during CRC negotiations, representatives of Senegal proposed the inclusion of a new article emphasizing a child's duty to respect and support their parents if necessary. Although some delegations supported the idea, others argued that respect for parents was a moral rather than a legal obligation, and thus inappropriate for the Convention on Children's Rights. As a result, this article was not included in the final text, and as I'm Azerbaijani myself, I will provide an example of Azerbaijan's law on the right of the child, which is 1998. In this law, it is codified both children's rights and responsibilities, including respecting parents, adhering to social norms, and safeguarding national symbols, historical monuments, and the environment. And this reflects a holistic view of rights and duties that is fundamental in many cultures, what was sidelined in international negotiations in favor of Western individual rights framework. And another example concerns the intersection of gender norms and legal frameworks is about marriage age. Early debates on marriage age focused on physical maturity to protect girls, overlooking socio-economic factors like poverty, leading to resistance against legal minimums seen as external, imposed, and culturally inappropriate. These cases show the need for child rights framework to integrate both cultural understanding and structural reform, moving beyond colonial and patriarchal system to genuinely empower children and their communities. Thank you.
Great, thank you so much, Mark.
Yeah, on this, I think one critique that can be made, which has already been raised earlier, is the fetishization of chronology, and this measurement of the Gregorian calendar of time, making so much hay out of a single birthday as the sine qua non of when one sort of magically crosses the transom from childhood to adulthood. That's of course embedded in the CRC, as being the age of 18. This is sort of like the abracadabra of when you're no longer young and now you're just in this, the morass of adulthood. Now, chronology is easy. Law loves it. It's simple. It's straightforward. Supposedly, you can measure it, although it can be hard to measure in some cases because there's lots of places in the world where people don't have, passport documents that pinpoint the exact day in a Gregorian calendar on which they were born. But still, chronology is easy. Law likes stuff that's simple like that. It's measurable. It's in numbers. So somehow it seems to be, adduced and seduced by the magic of quantitative approaches as opposed to things that are more experiential. But the point of the matter is, in most places in the world, most of the time, and muchly so, age is seen as experience. Age is seen as coming of age. There's many societies in which a teenager who's married and has children is seen as an adult, whereas some like 40-year-old, your uncle who never married, never had kids, is still living with the brother, is actually not really seen in an adult-like capacity in any fashion. And I think these kinds of things matter greatly. So I would say one thing that we also see as a byproduct of this Cartesian notion of law is this real focus and fixation on chronology as opposed to coming of age. And this is something that I've commented on. Um, but I also think it's important in this conversation just not to go on and on about how, colonial theory and the West is this font of iniquity all the time. It's just too easy to say that. Because I also think that in many places in the world, we have a reality that there are nuggets of really interesting approaches that resonate cross-culturally, whether spiritually or in sort of classical liberal philosophical theory, whether in the West and elsewhere. And one of those nuggets that I think is very promising looking ahead is the idea of intergenerational equity. And this idea that the generations of today owe something to the generations of the future. So, in a theory of justice, when Rawls comes up with this veil of ignorance, from which, we're supposed to devise the best society because we won't know anything of ourselves when we construct the society. Rawls doesn't include time. But now you've got a bunch of activists, and often including also spiritualists, who are saying we need to think of time. Where we see this notion of intergenerational equity really being mapped on, interestingly, is in the area of the environment. And this is an area where young people have actually turned to litigation, notwithstanding being minors or adolescents, and have secured constitutional outcomes. There's very interesting litigation that's been ongoing in Montana, in the United States. There's litigation in Germany, where you have young people who've brought cases that say that when we think of interpreting constitutional provisions today, we need to be mindful of the effect of our decisions today on young people and also new generations of people. And when we think of sustainable development, we think of this notion that the footprint we leave today should not impede future generations from having their own ability to have their own footprints on the quality of the environment. It's also very interesting to me, however, on the human rights narrative, and let me sort of wrap up with this, that we think that all human rights are in a bundle. They're all loving each other, they're all simpatico one with another, and they all work together. But the fact is that's often not the case. Rights can be in competition one with another. There's many countries that have made huge forward strides on gender equality and are autocracies, and there's no freedom of expression. I think when it comes to environmental well-being, and the promise of intergenerational equality and intergenerational equity, and the fact that those not yet born have some rights, this is often sharply contested by individuals who are concerned that conversations about intergenerational equity in the environmental context may lead to limitations placed on choice in reproductive freedom. So I think we also need to recognize that this march of human rights, in which children's rights play a role, is not always in solidarity with all other kinds of rights at the same time. But I did want to throw in, and I'll stop on this, that I've become extremely interested in the intersection of young people and the environment, to think of human rights in a much more expanding sense, and also to think of the rights of non-humans. And I think at the end of the day, this kind of agency by young people bringing forward their own cases on this, I find that really, really inspiring. So I wanted to put in some optimism and some redemption for Western courts and, Western philosophical theory as well, not to the exclusion of anyone else, of course.
Great. And on this note, thank you so much. That's actually very illuminating. Shall we, I guess now we should just wrap up and open the floor to question as we have progressed a little bit. Thank you so much, all of our speakers, Natalia, although in absentia, Mark and Isel,